Text line 601-879-4395. No name, but it says, gentleman wrote in, said, my wife fell on a Disney trip, and I'm assuming because he said in Florida. So at Disney World or Epcot or one of those facilities, he said, do you have an attorney in Florida that can help get her medical bills paid? She has Blue Cross Blue Shield. Well, guess what? She went to UMMC. UMMC's now in the battle with Blue Cross Blue Shield over insurance. So to answer your question, that's great. Florida law does apply. So Florida premises law does apply with regard to whether there's fault or not fault. Neither Brett nor I are licensed in Florida. We do not have any licensed attorneys in Florida in the office. But you hit the nail on the head. I know lots of Florida attorneys, and we handle Florida cases by connecting clients that live here in Mississippi with Florida law firms, have wonderful referral relationships with Florida firms. So you absolutely can call the office at 601-988-8888, and they will get some information. They'll actually pass it along to me, Patrick, and then I will reach out to one of our referral partners. Generally, I will tell you, premises cases are very challenging. Very tough, because the standard basically is that business knew or should have known of the dangerous condition. So you're going to have to figure out of what exactly made your wife fall, and it was something that, was it dangerous or, that they knew, Disney knew of, or dangerous that Disney created, or is it just an accident? And most premises cases are literally just an accident. We got a workers' comp question. Brett is an outstanding workers' comp attorney. Says, how long can an individual stay off of work on a workers' comp case?
Well, that's a great question. So, and there's a couple of different ways to really answer that. As long as your doctor has you off of work as a direct result of your work injury, then you can still be, technically on your workers' comp case. That can continue really forever, really. But typically the benefits only last a certain period of time. So there's a cap on benefits in the state of Mississippi. 450 weeks of compensation is the most that any one individual can get while off of work for their work-related injury. So there is a cap. It is a limited benefit, but technically there are ways to keep your case open and active really for many years to come if you continue to treat for that injury.
And if you can give, because you do such a great job with workers' comp, kind of give everyone the Cliff Notes version of what creates a workers' comp case, what you're entitled to, and what it takes to prove, an on-the-job injury.
Right. So it sounds simple enough, but can be difficult in certain situations. But workers' comp is there to provide benefits for people who've been injured during the course and scope of their employment. And that could be a lot of different things, whether you're driving a car, going from one location to another, and you get in a car wreck. Well, that's a workers' comp case. If you slip and fall, if Patrick gives me a ladder and says, go change this light bulb, that's not really part of my job, but if my boss told me to do it and I fall off the ladder, I'm an attorney, but hey, I got hurt at work, so that is a workers' comp case. So what are you entitled to? Medical care at no cost to you. It has to be provided. You get to pick your doctor, and in Mississippi, you only get to do that one time, so it's very important to pick a good doctor and maybe not get steered to a certain doctor by the insurance company, which does happen quite a bit. But you're entitled to medical care until you reach the point that the doctors say you're good to go. You may not be 100%, and you may not be better than you were before, but they've done everything they can to get you back as best they can. And while you're off of work, you're entitled to what we call temporary total disability payments, and those are checks that you would receive from the insurance company. They are a reduced percentage of what you made. So a lot of folks, Patrick, struggle financially when they get hurt on the job because you're used to getting paid, $600 a week, and then now you're only getting paid $400 a week. It's tough. Mm-hmm. But that is a benefit that people are entitled to in Mississippi is those temporary total disability payments. And at some point, once you get released, and this is where really the benefit of having an attorney comes into play, is evaluating your case and trying to maximize the settlement or award if you have to litigate it. And that's where an attorney can really come in and help, get you the best possible settlement or an award out of a judge that you can.
Asked Brett, workers' comp attorney extraordinaire, difference between I hurt my back and can't do the same job now versus I broke my arm and ultimately it recovers and I go back to doing what I was doing.
Right, and so there's two different types of work-related injury claims under the law in Mississippi. You have body as a whole, which is your neck, back, or head. And then you have scheduled member injuries, which, as you know, it could be your arm, your leg, your fingers, your toes, and those are called scheduled member injuries because there's a set number of weeks for each body part. It's kind of weird, but that's the way it works. So an arm, get this, is worth 200 weeks of compensation. If you had your arm amputated as a result of a work-related injury, then 200 weeks is the absolute most a judge could give you, provided there aren't some other factors. There's always a but when you're talking to lawyers. But so those are the two main types of injuries. So a back injury, what you're looking at there, especially if you cannot go back and do the type of work you did before, then it's all about what is your loss of wage earning capacity, which is a fancy way of saying how much money can I make now versus what I made before as a result of the injury. And that's where the value derives when you're talking about a back injury case. So an arm case would be something different. It's still capped at that 200 weeks, but the doctor gives you an impairment rating of 10%. Well, that's worth baseline 20 weeks. And then anything in excess of that, you've got to prove what we call industrial loss of use, which is really just another fancy way of saying you can't do what you could do before. So that's the name of the game in comp, is the impact that the injury has on your ability to work.
And the thing is with us, because it's you, and we have two other workers' comp attorneys, so there's three of y'all total. We have lots of scheduled member cases. We have lots of wage earning capacity cases, and all those come into play because, you think about, it's just a broken arm, it's going to recover, but then complications happen or,
right.
You don't regain the same strength you had, so it does impact your ability to work. So, we're there for, all sorts of on-the-job injury cases at the firm.
And we've had unique injuries. We've had some illnesses are covered. We just got through one of the strangest periods of my life and your life too, I'm sure, the COVID pandemic. We did have some COVID cases. Of course, those were the unfortunate circumstances where people actually died, as a result of those injuries. And we had to prove to the best of our ability that they got it at work, and that would be covered under workers' comp. And we've had some other illness-type cases, but for the most part, what we deal with here in Mississippi, we're a hard-working state. A lot of people doing heavy, manual labor jobs or just jobs that require a lot of strength, and a lot of injuries, a lot of back injuries, neck injuries, but also, broken legs, arms, torn ACLs, meniscus. It runs the gamut, and we get involved in all those cases, get involved in all different stages of the claim. We have people that call us the day after they get hurt, and then we have people that call us, 2 years down the road, and that's fine. But just call us. I think you're going to be better off having an attorney than not. But we will take the case, whenever you need us to help you with it.
Yep.
So.
And the statute in a comp case is shorter than it is in a general injury case, so that's something to remember.
It is. So the general, it's a moving target too. Comp is strange in that way. The standard statute of limitations, which, as I'm sure you've explained on the show before, if you miss that, then that case is over. It's done.
Yep.
But it's 2 years from the date of the injury if they haven't paid you any money for being off work. So I have seen letters from adjusters right after the 2 years passes. They're paying for your medical treatment, but you're not off work. You never missed a day of work, but you're still treating. Then you get a letter in the mail that says, well, we're not going to cover your treatment anymore.
Yep. Because
the 2 years is run. And I think it's a really unfair part of the law because people are kind of lulled into this false sense of security, not knowing. A lot of people don't know what the statute is.
Absolutely.
So that's why I think it's always best to try to get some advice, hire an attorney if you need to, because they, and by they I do mean the insurance companies, they do not have your best interest at heart for the most part.
No, you're exactly right. That's why you hire a law firm for a workers' comp case, for a car wreck case, for a slip and fall case, because once you hire that law firm, they have an ethical duty to zealously represent you. I mean, the insurance company has an ethical duty to represent who pays that premium. Mm-hmm. You know, in a workers' comp case, that's the employer. That is who their client is. It's not you, the worker. Well, Kirk, who texted in earlier, asked a second question, which is great. So thank you so much, Kirk, for texting in on the C Spire text line, 601-879-4395. He said, part two of his question, my injury was caused by a third party, and the third party files bankruptcy. Is the employer responsible for the settlement to the employee for the injury?
No. So we do have those cases all the time where someone's hurt as the direct, result of negligence of a third party, and you can sue that third party separate and apart from your comp case and get a recovery. But if they go bankrupt and there's no one there to, cover that claim, then that claim's that's done. Now, your employer, through the workers' comp carrier, would be responsible for a potential resolution of your workers' comp case, but they would not be responsible for paying, the settlement on that third-party claim.
Next line, 601-879-4395. He said, part two of his question, my injury was caused by a third party, and the third party files bankruptcy. Is the employer responsible for the settlement to the employee for the injury?
No. So we do have those cases all the time where someone's hurt as the direct, result of negligence of a third party, and you can sue that third party separate and apart from your comp case and get a recovery. But if they go bankrupt and there's no one there to, cover that claim, then that claim's that's done. Now, your employer, through the workers' comp carrier, would be responsible for a potential resolution of your workers' comp case, but they would not be responsible for paying, the settlement on that third-party claim.
Yep. Hey, Tim just texted in, so workers' comp's been a hot topic today. He says, why is it in Mississippi that companies that have less than a certain number of employees are not required to carry workers' compensation?
You would have to ask your state legislature about that, but a lot of states do have that same requirement, and in Mississippi, it's 5 or more employees got to have it, unless you fall into one of the other categories that's exempt, like farm labor, domestic labor. Those are categories where for whatever reason, the state said, no, you don't have to have coverage. But even though you're required to have coverage, we've run into several situations where an employer's got more than 5 employees and they still don't have it, which causes a whole new can of worms to get open, but you can still recover. Just a little bit harder. But yes, state law is that you have to have 5 or more employees to be required to have workers' comp coverage.